Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, okay? And basically, so far we have covered right to equality, okay? Thereafter, right to freedom, okay? Thereafter, right against exploitation, okay? And then right to personal life and liberty, okay? Which is also the part of right against conviction of offenses. And then in the previous lecture, we had started the discussion over right to culture. Okay, so that is the picture that we have created so far altogether. All right, so basically we will continue from where we had left in the previous lecture. So in the previous lecture we had started the discussion over the topic of right to culture, right? And basically in this topic there are two articles, article 29 and then article 30. Okay, so in the previous lecture we have done with the article number 29. In this lecture basically we will start with the article number 30. So basically if we talk about the previous lecture, so we had discussed about the right to preserve linguistic culture, script and cultural customs of distinct nature. Okay, so that's the thing. Thereafter we had seen the majority ones, and then the minority ones. These are the two sections of the society that we had covered. All right, and even we had covered that there is a Supreme Court verdict which states that the right to preserve the culture is available for minorities as well as majorities. Okay, so that is the thing that we had covered in the previous lecture, or you can say that's the conclusion of it. All right, so I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture, as many times I have told you the same thing, that it is for your own benefit. So if you are doing this on the regular basis, the thing will be very, very beneficial for you. If you are not doing this on the regular basis, then the thing will be difficult for you. Okay, so with this note, let's start with the another one, which is the right of minorities to establish and administer the educational institutions, as promised by Article 30. Okay, So here I hope that I am not required to tell you about the majority and the minorities, because in the previous lecture I had told you. But here what I will do, that I will just make a quick revision for you so that you will be able to connect it with the previous ones. So basically in the previous lecture we had discussed that if there is a population of an area or a territory, okay, so there are chances, or there is a reality, not chances, that the population will not be a homogeneous one. Okay, it is highly practicable that the population will be a heterogeneous, which means that the population will have different cultures, different customs, different language, different script, and different rituals. All right. So if the population is heterogeneous, so there will be a two sect of the population: majority ones and then the minority ones. Got it? That thing will be happen. Majority ones are basically those who having enough, you can say, representation in the population, that their culture, their religion, their script and all will be propagate easily. But the minorities ones are those which do not having adequate representation in the population. So there is a possibility that might be they will be forced to convert into the majority ones, or you can say they won't be able to propagate it further. All right. So that's why there is a protection which have been provided for the minority ones. Got it? That's the thing. Now, after finishing this, let's come to this. So basically, there is an Article 30 which grants the following rights to the minorities, whether they are linguistic or religious nature. Okay, whether they are of religious or the linguistic nature. First thing is, all minorities shall have the right to establish and administer the educational institutions of their choice. All right. But if we're talking about the educational institutions, suddenly I recall the one thing. What is that? Like we had seen in the previous to previous lecture, that there is an Article 28. Okay. And we know this Article 28 basically comes under the right to religion part. Right. And there is a provision about the educational institutions. Okay. Or you can say about the religious education in institution. Right. That's the thing. So now my question is that there were four types of religious institutions identified under the Article 28. All right. So now you are required to tell me that what were those four types of institutions. For that, you have only 30 seconds to think an answer. Then I will give you the answer. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, the times. So let's talk about those four types. First is administered and maintained by the state. Here you can correct it. It was established and maintained by the state. Second one was maintained by state but established under some trust. Okay. Thereafter got recognized by the state. Okay. And thereafter last one is got funding by the state. All right. So these are the 4 established and maintained by the state. Thereafter second one is maintained by the state but established under some trust, got recognized by the state, or got funding by the states. All right. These are the 4 So similarly, here is the educational institutions, but these are established by the minorities. All right. And the minorities of 2 types, like there are 2 types of minorities. First is linguistic minorities. Thereafter, religious minorities. Okay, this is the thing. Second provision was that the compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. Okay, which means that the government may acquire under the compulsory acquisition any property of the minority educational institution, and instead of this, the government will give the compensation to them. But this should not be done accordance that this will restrict or abrogate the right which had been guaranteed to them. Okay. This provision was added by the 44th Amendment Act of 1978. Okay. So that the right of minorities could be protected in this regard. Why? Because we know that if we talk about in India, all right, so in India there are the 3 types of properties in general. Okay. One is the state property. It means the property comes under some state department, whether it's a central or the state level. Thereafter, the public property. It means the property which is open for all. Okay. And then comes the private property, the property which belong to some individual or some group of individuals. All right. So these are the 3 types of properties basically we have in India. But what generally happen, like the government under the compulsory acquisition scheme could cover the public property as well as the private property. All right. But the same power could be applied on the educational institutions which had been established by the minority. All right. So basically for this, to protect the minorities, The 44th Amendment Act of 1978 presented one provision that the state is allowed under the compulsory acquisition scheme that they could acquire the property of minority education institution, and instead of this they could give the compensation amount to them, but this should not be done in accordance with this will restrict or abrogate the right to them. All right. Thereafter, another thing was this: the act deleted the right to property as a fundamental right. Like we had discussed that originally, if we talk about the constitution, then the constitution basically having the seven fundamental rights. All right, but later on, these sevens were deleted, and now we have six fundamental rights. Okay, so that is the thing. Thereafter, in granting it, the state shall not discriminate against any educational institutions managed by the minority. Like we know, the state basically having so many schemes for the educational institutions, all right, which also included the educational grants. All right. So basically, there is a provision that the state should treat everyone on the equal basis. Okay. So we could say that the state should not discriminate against any education institution managed by the minority, so that the equality of things could be ensured. Okay. Thus, the protection under Article 30 is confined only to the minorities which are religious or linguistic. Does not extend to the any section of citizens as the Article 29, because we had seen that basically that is a Supreme Court verdict that the protection of culture and all under the Article 29 is available for both the minorities as well as majorities, right? And the reason was very much clear. What was the reason? Like Supreme Court, instead of mentioning any particular group like the minorities and majorities, basically the Supreme Court held that it is applicable for the sections of society or sections of population. All right. And if we go by the statement, it means the sections of population. So basically, we know that's the population having the two sections, the minorities and the majorities. Okay. But there is one another, you can say, important fact and interesting fact, I will say. The fact is, however, the term minority has not been defined anywhere in the constitution. Okay. Like we have been discussing upon the Article 30 for last few minutes, and then we got the Article 30 is talking about the minorities, but the minority word itself haven't been defined in constitution. So what does it mean? It means the right under Article 30 also includes the right of a minority to impart education to children in its own language. Okay, so this is the thing. All right, like if we talk about the language of education, all right, so it is you can say it is a very common thing that the language of education usually a language of masses. Okay, it means that it is the language of majority. Right? That's the thing. So here, what we are getting, like, the perseverance to the language is not only that they will get education institutions and all. Okay, even in their educational institutions, if they do not want to provide the education in the masses, then they could provide it in their own language. Okay, for example, if we talk about the Mathi community, please pardon the spelling if it might be wrong. Okay, if we talk about the Mathi community, then Mathi is the minority group in India. All right. So if any institution was established by the Mathi community, so it's their right whether they want to continue the education in English, or you can say in Hindi, or continue it in the Mathi. All right. Thereafter, if we talk about the types of institutes that we covered under the minority educational institutions, so basically there are the three types. First is that institutions that seek recognition as well as aid from the state. Okay, it means that recognition as well as the aid. All right. Thereafter, institution that only seek the recognition from the state and do not seek the aid. All right. Third is the institution neither seek recognition nor aid from the state. Okay. So here we have find out that there are three types of educational institutions under the minorities. And what are these? Let's, or you can say, let's remember them by writing their names. Three types of institutions. Okay, let me write down here, here, and here. Seek, recognition, and aid from the state. Both the thing. Thereafter, seek, recognition, and not aid from the state. Third is seek neither recognition nor aid from the state. Okay. So keep these three type of institutions, okay, in your mind, because the questions might be asked you. All right. So now let's talk about it. So the institutions of first and second type are subject to the regulatory power of the state with regard to the syllabus prescription. What will be the syllabus? What should be the academic standards? How the discipline will be maintained? What are the sanitations required? Employment of the teaching staff, and so on. Why? Because both the things, the administration as well as the finance, both are powering by the state or the government. Thereafter, the institution of third type is free to administer their affairs, but subject to the operation of general laws like contract law, labor law, industrial law, tax law, economic regulations, and so on. Okay, in which they are not provided with the self-governing autonomy, or you can say instead of governing, self-operating autonomy. Okay, so that's the thing. So we can say the first two are having the influence of the state. Okay, having the influence of the state. But the last one have nothing to do with the state except the general field or law field. Okay, because in these two fields, like the general laws, like contract laws, labor laws, industrial laws, tax law, economic laws, they do not have the self-operating autonomy. Got it? Thereafter, in a judgment delivered in the Secretary of Malankara Siren, okay, that is a case. Okay, so basically that was a Catholic College case 2007. Please remember these cases name because these are important from the examination point of view. There are chances that might be the question will be asked from any of them. Okay, so there was a Catholic College case 2007 when the Supreme Court has summarized the general principles which are relating to the establishment and administration of the minority education institutions. And these are the following ways. The first is right of minorities to establish and administer the education institutions of their choice comprises the following rights. The first right is to choose its governing body in whom the founders of institutions have faith and confidence to conduct and manage affairs of the institution. Okay, so they could choose these type of bodies by themselves and there will be no, you can say, interference by the outsiders. Okay, thereafter, the second important thing was to appoint teaching staff like teachers, lecturers, and masters and the principals, as also non-teaching staff, and to take account if there is direct, you can say, direction of duty on the part of any of employees. So basically, this is totally depend upon the administration of the education institutions registered there. Thereafter, to admit the eligible students of their choice and set reasonable fee structures. Thereafter, to use its properties and assets for the benefits of the institution. So these things were basically granted under the Catholic College case, which was happened in 2007. So the right conferred on the minorities under Article 30 is only to ensure the equality with the majority and not intended to place a minorities in more advantageous position vis-a-vis the majority. Okay, there is no reverse discrimination in favor of minorities. The general laws of the land related to the national interest, security, social welfare, public order, morality, health, sanitation, taxation, etc., applicable to all, will equally apply to the minority institutions also. So there is only the protection granted to them, not fully covered. Thereafter, a right to establish and administer the education institution is not absolute. It means that there must be some restrictions, nor does it include the right to maladminister. There can be regulatory measures for ensuring the educational characters and the standards and maintaining academic excellence. There can be checks on the administration as are necessary to ensure that the administration is efficient and sound so as to serve the academic needs of the institution. Regulations made by the state concerning general the welfare of students and the teachers, regulations laying down eligibility criteria and qualification for the appointment to be as a staff, also the condition of services of employees, both at the teaching and non-teaching, regulations to prevent the exploitation and the operation of employees, and the regulations prescribing the syllabus and curriculum of study fall under this category. Such regulations do not in any manner interfere with the right under the Article 31, right to establish and administer the educational institutions. Subject to the eligibility conditions, qualification prescribed by the state being met, the unaided minority education institutions will have the freedom to appoint teachers, lecturers by adopting rational procedure of selection. Okay, it means that however the autonomy has been granted to them, but still the government could put the restrictions and the checklist on some general aspects. Thereafter, if there is an extension of the state by there is an extension of aid by the state, it does not alter the nature and character of the minority education institution. Condition can be imposed by the state to ensure the proper utilization of aid without, however, diluting or abridging the right under Article 31. Okay, so that's it. So students, basically in this lecture we have finished till here. In the next lecture we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture, and what do we say? We say thank you.